Okay, welcome back, everyone. We are about ready to get started on our second session of the day, which again focuses on domestic case law developments since the close of the comment period. I've been asked just to remind everyone, all of our panelists, to please remember to speak into the microphone when you're making a comment, and then if you could please turn off your microphone when you finish speaking, that will help from the audio recording standpoint. So again, as before, I'd like to invite our panelists to introduce themselves and to state their affiliation, and then again, we invite you to just make a very brief summary statement, and we urge you again to please try to keep those to about 45 seconds. So we'll start with Mr. Band.
So I'm Jonathan Band, and I represent the Library Copyright Alliance. We're most concerned with the Ninth Circuit's decision in Mavericks v. LiveJournal. In Mavericks, the court found that a service could lose Section 512 safe harbor by virtue of moderating the content being uploaded to its site. Thus, a service provider that complies with the EU's new filtering requirements could find itself losing its DMCA filter. This is a perverse result. The Motherless decision may undo some of the damage, but Mavericks remains a potential landmine. Thank you.
Sofia Castillo from the Association of American Publishers. AAP continues to believe that a legislative fix to Section 512 is necessary to ensure that ISPs that rely on copyright infringement as their business model are not eligible for safe harbor protection. The decisions in Cox and Grande provide helpful elements that the Copyright Office might include in its report with respect to defining a reasonably implemented repeat infringer policy. Similarly, to address the contours of platform responsibility, the Copyright Office might look to the rulings in LiveJournal and Motherless, which clarify that screening material for potentially infringing content does not expel an ISP from the 512C safe harbor.
Stephen Carlisle of Nova Southeastern University. I need to preface my remarks by all of my comments here today are my personal opinion and do not necessarily represent those of Nova Southeastern University. Through the good graces of Nova, I have managed to maintain one client for my previous law practice, a small music publisher of jazz who has perhaps 100 songs. From our viewpoint, 512 is simply unworkable. The whack-a-mole program on its own makes it simply unaffordable from a time standpoint and a financial standpoint to send out the number of notices required. As to the red flag knowledge, which was discussed earlier, I did this last night, courtesy of my good friend sitting next to me, Google. I put the name of my artist into a Google search. What I got back was recommendations for 2 videos. Both of these videos consisted of nothing more than my client's song with a static image of the album cover. Top 2 hits. Now, as far as red flag knowledge, I think if you have an entire work that is not modified in any way, so that can't possibly be fair use, and all there is the album cover on there, I think that's sufficient to confer red flag knowledge.
Thank you.
I'm Caleb Donaldson for Google. The DMCA framework provides a balanced approach to intellectual property enforcement, and we can see that in the flourishing of not only the tech sector, but the creative industries as well. We've heard already about the volume of searches that a video that is uploaded to YouTube. We haven't heard that those videos have paid $6 billion in ad revenue to the music industry alone. But the creative sector is not just established industry players. A study last year showed that in 2017 there were almost 17 million American independent creators offering their works for money online. So this just shows the variety of creativity that the DMCA can support. It's also laid the foundation for Google's best-in-class rights management tools. Not only our $100 million investment into Content ID, but also our bulk removal tools from search results. We processed 693 million requests to remove URLs from search results last year, and we did it very quickly and with a high degree of accuracy, and we're very proud of those tools. And all of that rests on the framework of the DMCA. Thank you.
Thank you.
I'm Ken Dorshow. I'm with the Recording Industry Association of America. And I know there's going to be a certain amount of redundancy from this morning, so I'll try to edit on the fly to keep that to a minimum. But from the perspective of the recording industry, little has changed over the 2 years since the last comment period, and we stand by our comments from a couple of years ago. Cases like Motherless, for example, continue the trend of judicial opinions that read the red flag knowledge requirement out of the statute. We are pleased to see those repeat infringer cases that the office has noted, the BMG Cox case, the Grande decision, but we hesitate to take too much comfort in those decisions because, as was discussed this morning, they don't really teach us very much. These were very extreme cases, and it shouldn't be controversial or newsworthy that a service provider that effectively has no repeat infringer policy is not entitled to the safe harbor. And of course, the Motherless Court's willingness to excuse evident problems with that particular service provider's repeat infringer policy suggests that even BMG versus Cox and Grande can't be taken for granted. So,
Thank you. I think we should move on. Thank you.
Sure.
Hi, my name is Doug Hudson from Etsy. We have 2 million micro-businesses and creators that might not be fully represented in some of these discussions. And in that, I think there's some points that they see that might come together between the two sides. One is that I've heard from IP owners and marketplaces and others that there's a dramatic increase in the amount of fraud in the process. Fraud in terms of false takedowns, in terms of phishing and scamming, and in terms of gaming the system. On the other side, people are seeing fraud in counter notices. I think we need to seriously look at 512F and find a way to put some more teeth into the process to protect both copyright owners, marketplaces, and end users. Second, I think we need to work on simplifying the DMCA for small IP owners, for micro businesses, for people who have a small library of materials. It's hard for them to use the process. And finally, there have been solutions here in Europe. People have recommended pre-filters. Pre-filters don't work for everyone. It's not a one-size-fits-all solution. When you deal in physical goods, when you deal in creative services that don't match digital content, it's not a viable solution. And so we need to understand how the flexibility of a system like 512 helps create things in all sorts of creative endeavors, not just digital audio or video.
Thank you.
Thanks.
Hello, I'm Keith Cooperschmidt with the Copyright Alliance. When it passed Section 512, Congress intended to encourage copyright owners and OSPs to work together to combat existing and future forms of online infringement. However, over the past 20 years, court rulings and other unanticipated changes in the online environment have rendered these provisions less effective, creating an ecosystem where mass copyright infringements are an unfortunate and regular occurrence, and ISPs are routinely shielded from liability and encouraged to avoid responsibility and accountability. Over the past 2 years in particular, we have experienced more of the same. The courts have effectively written the red flag knowledge standard out of the statute, and while there have been some good recent decisions relating to repeat infringer standard, these decisions are not the panacea that some would make them out to be. The Fourth Estate decision has compounded these problems by effectively adding a new requirement to the DMCA that the works be registered before sending a DMCA notice. If you combine these decisions with the new limits on the WHOIS database, there can be no doubt that we are clearly worse off than we were when we attended these roundtables 2 years ago.
Okay, thank you.
Art Levy, Association of Independent Music Publishers. Since the last roundtable, with some narrow exceptions, problems with the DMCA have gotten worse for independent music publishers and songwriters, not better. Courts continue to write copyright owner protections out of the DMCA, most recently in cases that have interpreted the Act's provisions on constructive knowledge and misrepresentation, among other issues. As a result, service providers have less incentive to work to prevent infringement, and it's even more burdensome for copyright owners to do so. The whack-a-mole problem has not been solved, yet ISPs continue to benefit from the safe harbor. And from the perspective of indie publishers, songwriters, and other small copyright owners lacking the resources to enforce their rights under the DMCA essentially offers them no remedy. The Copyright Office should promote significant DMCA reform, seeking a rebalancing of the DMCA.
My name is Peter Midgley. I'm the director of the Copyright Licensing Office at Brigham Young University. We're a nonprofit educational institution, and because we're private, we don't enjoy sovereign immunity from copyright infringement lawsuits. We're here because we believe that universities are somewhat unique in the DMCA ecosystem. We obviously, our primary role is to educate our students, many of whom are dreaming about careers in creative industries. At BYU, our animation program and our advertising programs are among the most highly rated in the world. And so we definitely recognize the value of a robust copyright system. We're by no means copyright abolitionists, but at the same time, we are also service providers, and we manage a very large network to support our students, our faculty, staff, and even visitors to our campus. And in that context, we receive numerous 512C notices, and the imposition that it presents for us, the administrative burden in processing those notices, and the uncertainty associated and following the Cox and Grande cases are somewhat problematic for us as universities.
Thank you.
Thank you to the Copyright Office staff for inviting us all to speak here today. My name is Sasha Moss, and I'm here on behalf of the R Street Institute, a center-right think tank based in Washington, D.C. and the States. So as the internet has grown, so have the amount of takedown requests. As such, the burden has heightened for both rights holders and service providers to combat infringement. Now, consider this. Consumption of legal content is continually rising, as R Street and the Center for Democracy and Technology articulated in our last round of statements. In 2015, audiences legally consumed 3.5 billion hours of movies online. So as we see, as legal options become available, users will genuinely gravitate towards that option. Now, motivation might differ from user to user. Some users are afraid of pirated content might come with malware. Others may fear having their internet cut off for the entire household. Regardless, legal options, as they become available, will be used, and we need to continue to gravitate towards that direction. Not to end with, nothing's ever easy. This DMCA is written is not perfect, but as we know, perfect is the enemy of the good. And I want to thank you for your time and look forward to your questions.
Hi, Mary Rasenberger from the Authors Guild. The Authors Guild is a membership organization and advocacy organization with 10,000 members. We have a number, about at least a third of our members, maybe half, do some self-publishing. So they are trying to deal with piracy themselves. In the last 2 years, ebook piracy has bloomed. It is becoming a real issue. Frequent readers are more frequently reading from piracy sites. The new cases in the last couple of years only affirm the collapse of the actual knowledge and the red flags standards into notice and takedown. As we all know, notice and takedown is an absurd way to deal with piracy. 512 is not incentivizing cooperation as it was intended to do. And for authors, the main issue we're dealing with is that under 512, we cannot address the ebook piracy sites. That is the sites that are devoted to ebook piracy. They hide behind 512.
Okay.
We need to rethink 512 and switch the burdens to the ESPs, and I just want to suggest that we look to the EU directive as some kind of model.
Okay, thank you very much. I'd like to start this session with repeat infringer policies. Mr. Doroshow, I think you said that the recent cases don't have much to teach us, but nevertheless, I'd like to throw the question out there, a general question, and that is, to what extent have recent decisions on repeat infringer affected or clarified the state of the law in this area? And more specifically, does anyone see any conflict among the decisions? And I'm thinking particularly conflict between Cox and Grande communications on the one hand and Motherless on the other hand. Mr. Midgley?
Yeah, so I actually tend to agree that the recent case law has not been as helpful for those of us who are earnestly seeking to implement repeat infringer policies. I think what we have now are a couple of cases that make it clear that it actually isn't even clear if a 13 strikes and you're out policy is an adequate policy under the statute. What is clear is that if you don't enforce it, you're not eligible for the safe harbor, which really isn't all that helpful for those of us who are trying to implement whatever is an acceptable repeat infringer policy. We heard a lot of talk in the earlier panel about what constitutes red flag knowledge, and somebody said they would love to know how to put somebody on red flag knowledge. Well, as an ISP, I would love to know how to implement a repeat infringer policy that's going to be held to be adequate and what it means to reasonably enforce such a policy. I can just tell you in a university setting, we're somewhat unique because we have pretty close proximity to our subscribers. It's pretty easy what our policy is, at BYU at least, is to do our best to try to identify whoever was associated with a given IP address included in a notification of claimed infringement, which can be a very difficult process, and we can't do it all the time given the dynamic nature of our network, but when we can, we forward the notices on to the people involved. And just anecdotally, I can tell you that these are students that they see this big scary legal notice, they show up in my office and they say, I have no idea what you're talking about, I don't know what this is. And so I have, some rights holder on one hand telling me somebody has a problem. I have a student on the other hand saying, I have no idea. And now the question is, well, what's my obligation? I guess I'm one of the few ISPs that actually has a moot courtroom on my campus, so I suppose I could start holding hearings and have the students show up and invite the rights holders in, but I don't know if Cox or Grande or who else could take advantage of that process, and really whether it should be expected of us as ISPs. What level of adjudication, what burden do we bear as ISPs to ferret out what are actual instances of infringement?
Could you elaborate a little more on sort of what's taking place with respect to these notices the students are getting? I mean, what sort of activity are these targeted towards? Is it sort of peer-to-peer activities that go to you and then you forward them to the students, or how does the process typically work?
Yes, so in almost all instances, we get these notices. They purport to be under 512C, but they're really aimed at 512A activity, which again makes it very difficult because in order to even do any kind, we're different than YouTube. We don't have a copy on a server that we own and operate that we can go and check. This is just content that has flowed through our network, and to be eligible for 512A, we can't keep copies of it. We have no way of verifying whether or not, the only thing we have to go on is the fact that a rights holder has sent us a notification. So we do our best to identify who's involved. We forward the notice on, and what we do at our campus, we refer the matter over to our honor code office, which does have some fact-finding capability that we don't have in our office, and so to the extent a student wants to dispute it, they can go and avail themselves of that process. But
so it sounds like at BYU under 512A, you take these notices as indicative data as to whether or not there's an infringement problem, right?
That has been our current policy. Again, we're looking at the Cox case and the Grande cases, and we're left wondering what precisely is an adequate repeat infringer policy. I don't think the courts have told us that, or the statute certainly doesn't appear to tell us that. And so we're just, doing what we think is reasonable and hoping that it will, that if and when we're challenged, that we will be eligible for the safe harbor under 512, given the policy that we've adopted.
So it sounds like you would favor the statute having more specificity. Is that correct? I mean, and I guess, the second part of that question is that obviously we've heard from a lot of people that the repeat infringer policy was not intended to, and should not sort of impose a one-size-fits-all policy. And so I wonder what your response is to that and what your sort of suggestions are for ways that would provide more clarity to universities and others.
Yeah, so I do think, I agree with the notion that a one-size-fits-all policy does not work very well. Again, I'm here as one example of a large number of organizations for whom internet service is not our primary function. It's an ancillary function that we provide. If I were the general counsel of Cox or Comcast or some other more traditional ISP, I would be paying very, very careful attention for us as a university. And there are lots of organizations that have broadband access to supplement some other service they're providing. And so, one of the things that we have to consider is whether or not the potential liability associated with providing internet access is justified by the benefits that are provided. And, you know, again, with statutory damages and all these other things looming out there, I think that's a very real conversation. So that's something the office needs to consider is, you know, if it's difficult for the Coxes and Grandes of the world to adopt and reasonably implement repeat infringer policies, how much more difficult is it for those of us that aren't in traditional ISP businesses to, you know, wade through all of the statutes and the case law on this. My final point, I guess, would be, at least in the university-specific context, there is 512E, which is, I don't know what its original intent was, but I can just tell you as somebody who's a copyright officer at a university, it's virtually useless. So if you wanted to do something specific for nonprofit educational institutions, which I do think would be a worthwhile thing to do, I would encourage you to consider clarifications and revisions of 512E, and I'd be happy to talk about that further.
Thank you.
Kevin, so I just want to ask sort of a practical rather than a legal question. Does your university either post what its repeat infringer policy is or communicate that to rights holders once they've complained about a particular student or particular traffic on your network?
Yes, our repeat infringer policy, it's available on our internal university policy network. It's publicly viewable through our website, copyright.byu.edu. I encourage everyone to visit. And so, and we one other issue, again, this is a university-specific issue, but we also have to deal with the Higher Education Opportunity Act, which includes provisions specific to copyright infringement. And so in compliance with the HEOA, we send out an annual notice to every member of our university community, all faculty, students, and staff, that make them aware of our repeat infringer policy, direct them to legal alternatives, and, you know, the other provisions that are in the HEOA. So that's another area. Again, if you're looking to do revisions and specifically aimed at the nonprofit educational sector, I would encourage the office to consider the interplay between the HEOA and 512, which it's not clear to me that that was considered in the original implementation of those two statutes.
Thank you. Mr. Brand?
So we, the Library Copyright Alliance filed an amicus brief in the Cox case, and what we were concerned about was exactly sort of this one-size-fits-all problem, and we wanted to make sure that, you know, the court didn't sort of say, okay, this is the standard and this is the standard that's going to apply to everyone. Everyone needs to have this kind of policy, because exactly as Peter was describing, I mean, certainly universities are one kind of service provider, libraries are another kind of service provider. For many Americans, you know, who aren't in school, I mean, they're the place where they get internet access is at the library. And so it's very important that you know, that the sort of the standards that apply to Verizon and Cox and Comcast not necessarily be the standards for you know, for a policy, a repeat infringer policy for a university or for a library. I mean, we don't see a need for statutory amendment. We think the language as is provides enough flexibility, especially because the idea of appropriate circumstances. And let me just also add, just to take a step back, and this sort of connects to points made in the previous session, and maybe you'll be getting to that here too, less about the constitutional dimension, about the importance of internet access, but more the practical concern. So as I indicated, for many, you know, for something like 30 or 40% of the population, the only place where they can get broadband access is at the public library. I mean, we all walk around with our iPhones, but a lot of people don't, or they're in regions where there isn't good coverage. And the access to the internet, I mean, it's in a sense, it sort of goes beyond the First Amendment. I mean, it really goes to the ability to function in this society. I mean, as we've read stories, I mean, you can't apply for Medicaid in places, or you can't meet the Medicaid work requirements unless you file things routinely on the, you know, on a website. So that assumes that you know that you have internet access and that you know how to use a website, and that you can know how to make apply for things online.
Do you think libraries should educate, I mean, they probably do, right, about the need to not infringe copyright if you're depending upon this, right? Like repeat infringer, you have more than one, you have to repeatedly infringe in order to be potentially terminated.
Right, no, and you know, certainly libraries, particularly in the higher ed situation, take that very seriously. And they have the same Higher Ed Opportunity Act requirements. But my point is this, is that when we're balancing the issues relating to terminating internet access, we need to be aware it really goes beyond, I mean, even though the First Amendment is important, you know, I'm saying it goes, you know, it's the, you know, right, you know, life, liberty, and the pursuit of happiness. I mean, you can't do those things in this country unless you have internet access.
So, go ahead.
I just want to ask a very maybe hyper-technical question. Does LCA view the fact that libraries provide the physical facilities to access the internet as making them 512A ISPs?
Yes, we do. I mean, because we're, you know, we feel we fall squarely within the definition of 512A.
Related to that, then I have two follow-up questions. One is that in LCA's initial comments, you wrote that service providers have been applying a repeat infringer policy that was actually at a higher standard than the law requires. I'm curious if you still feel that way and exactly what that standard is. And I'll add to that, and we haven't actually talked about this yet. This might be a good time to begin talking about it. But at the last round of roundtables, the service providers were largely saying that repeat infringer means adjudicated repeat infringer. That is not what the court said in Cox, and I'm wondering if that understanding among service providers has changed, or if they think that the court just got that wrong.
Well, there's, as this conversation indicates, there's lots of different kinds of service providers, and I'm sure you know, the different service providers have different opinions. You know, it would seem to me that you know, an infringer is an infringer, not an alleged infringer. That seems to me what the plain language of the statute is. But I agree with you. The courts seem to be going in a different direction, and you know, so that you know, I'm not an Article III judge, so I guess the law is what they say, not what I say.
So, just and one last follow-up question, just to sort of drill down. I mean, so, I mean, I think, you know, we take your point about the importance of internet access. I guess the sort of bottom line question is, so then what are you sort of suggesting in terms of either a potential change to the repeat infringer provision to accommodate these sorts of concerns? Is that what you're suggesting? Should there be a different statutory provision for nonprofit institutions? Should the repeat infringer policy not apply in those situations? I mean, what is the sort of bottom line proposal that you would favor?
No, I think the statute as written, you know, it's a little awkward, that provision, but, you know, because it's also talking about terminating infringers, which I don't think we want to do. We want to terminate the subscriptions of infringers.
I just mean that it
you know, just saying, I don't think that was that well drafted.
I just
but I don't think it needs. I don't think that oddity is enough to require congressional intervention. I think as long as courts continue or courts don't sort of start imposing additional restrictions on what appropriate circumstances, so that we, you know, a library can decide what's an appropriate circumstance, a university can decide what's an appropriate circumstance, and say, look, you know, because again, if you're a university student, you don't have access to the network. Right. You can't get your homework. You can't get your assignments. You can't.
Right.
You can't take your exams.
So, but I mean,
you
I
know,
guess so. The statute obviously contemplates that at some point, people will be terminated if they are repeat infringers, and right. Sorry, their subscriptions. That their subscriptions will be terminated, and I take your point about the need for that standard or, you know, appropriate circumstances to vary depending on the nature of the service provider. particularly given the importance of internet access. But on the other hand, that's what the statute seems to contemplate. So are you suggesting that, for certain institutions that requirement should not apply?
No. What I'm suggesting is that in your report, you talk about how appropriate circumstances could be interpreted in different, that what's appropriate at a public library or what's appropriate for a university may be different from what's appropriate for a large commercial service provider.
Okay, thank you. Ms. Castillo?
Well, first of all, I would like to push back or disagree with the notion that it was difficult for Cox and Grande to implement a repeat infringer policy. In those cases, it was clear that it was not difficult. They just decided not to do it. Cox had a policy, and it just decided not to implement it, and Grande didn't even have a policy, and it just decided to ignore all the millions of notices that it received for repeat infringement. So I don't think it's about difficulty levels in those cases. I think for purposes of the Copyright Office study, there are a couple of elements in the Cox decision that are helpful about repeat infringer policies in general, and it's what Mr. Greenberg was alluding to before about the concept of repeat infringer. The court said that a repeat infringer is someone who infringes copyright more than once, and there is no need for adjudication. And I think that is something that the court got right, and that the Copyright Office in its recommendation should stand for. Secondly, the Cox decision also ruled that repeat infringer policy should be assessed from an ISP's general practices, and I think that is also the correct interpretation of the law. Then in terms of what constitutes reasonable implementation of a repeat infringer policy, there are three things that the Copyright Office can include in its report. First is that an ISP should meaningfully and consistently enforce its own policies, whatever that policy is. It's true that we don't have guidance from the courts on that, but at least we do have guidance on meaningful and consistent enforcement of such policy. This is from the Cox decision. And then from the Grande decision, it's clear that an ISP should be keeping a log of repeat infringers in order to be able to say that it has reasonably implemented a repeat infringer policy. And in third place, AAP believes that ISPs should prevent terminated subscriptions or terminated users from opening a new account using simply a different email address or a different username, but still be the same person. These decisions are also helpful in pointing out what is not a reasonable implementation of a repeat infringer policy. So, for example, in Cox and Grande, the courts concluded that refusal to terminate known repeat infringers is one way to not comply with the statute. So I think that's an easy recommendation for the Copyright Office to follow through on. Another one would be the termination followed by the immediate or shortly thereafter, reactivation of repeat infringers. That also seems to be inconsistent with a reasonable implementation of the statute. And then on the question of the contradictions between Cox and Grande on the one hand and Motherless on the other, there are at least two problems with the Motherless decision regarding the repeat infringer policy. The first one is that 512I1 requires ISPs to inform their users and subscription or account holders of the repeat infringer policy. In Motherless, the policy was simply anything legal stays, and that hardly conveys to a user that there is a potential for termination if they repeatedly submit infringing content. Then another thing that the Motherless court got wrong was that it ruled that implementation of a repeat infringer policy based on the operator's personal judgment and without a log of repeat infringers was reasonable under the statute. We believe that Judge Rawlinson's dissent is very illustrative of why this is problematic, and we also think that the Cox decision with its standard of meaningful and consistent enforcement is actually more in line with Congress's intent in implementing the DMCA as a system of shared responsibilities between ISPs and copyright owners.
Thank you. Mr. Midgley, did you want to follow up?
Yeah, just a couple quick points. First of all, I am interested if there is any guidance on, unlike Cox or Grande, at least at our university, we're forwarding these notices on, and we do receive actual notice from the subscriber, to the best of our ability, that there is no infringement. And so what is an ISP to do if in the implementation of their policy they get conflicting information? What is that now considered an infringer when they've denied that they're an infringer? And whose word are we supposed to take, and how do we deal with that? That's a question. I would just also like to say that 512I1 refers to a service provider's system or network. This is a very important distinction in a university setting. We provide a network, which has the First Amendment implications we talked about. We also provide the system, which is how our students access our university. And if the statute isn't clear about what precisely we have to terminate, once we've decided that there's a repeat infringer, whether it's the system or the network, that's a very, very important distinction for us, and we would appreciate some clarity on that. I can just tell you that nonprofit educational institutions are notoriously risk averse. And so if uncertainty is going to make it very difficult for nonprofit educational institutions to continue to provide the robust environments that I think we all depend on to provide the socially beneficial functions of those institutions, if there isn't certainty around how to avoid, potentially catastrophic liability.
Thank you. I think I'm going to go to Mr. Donaldson and then Mr. Dorshow, and then unless there are further comments on repeat infringer, we're going to move to the next topic. Mr. Donaldson.
Sure. I just wanted to say that Cox on the one hand and Motherless on the other shows that the courts are getting involved in whether these policies are appropriate to the nature and purpose and size of the platform, and that truly one size doesn't fit all. I mean, these are sort of, they provide the cases taken together provide a good example of why it's hard to write a regulation that would cover all of this. Even putting aside 512A providers, the number of different kinds of 512C platforms and the different resources available to them dictates that repeat infringer policies will have some variation, and that's true not only from the perspective of a big company to a little company, but even within Google's 512C products, of which there are many. We tailor repeat infringer policies to the appropriate circumstances, given what the purpose of the platform is.
Mr. Dorshow.
This may help with the segue to other aspects of the 512, but I just want to make a comment about the importance of the repeat infringer policy and the termination requirements and so on. Very important, obviously. These are important developments with the BMG and Grande decisions, but they're not the be-all and end-all for a couple of reasons. First, if you look at the facts of these cases, in order just to make the point, to prove the case that there was a failure here, the rights owners had to send millions of notices. So there's a sort of an upfront burden that's put on the copyright owner that is really unreasonable, even to make this threshold bare minimum case that these ISPs had not implemented a repeat infringer policy reasonably. And then I think this is to echo Ms. Castillo's point from earlier. Even if you have a perfect situation, a perfect system of repeat infringer policy and terminations and so on, you still have the problem of users finding these infringing users finding other means of access to the internet, whether it's through a different service or because there's a lack of know your customer rules, they can show up again using different identification, different account information. So again, the real action, it seems to me, is the issue of red flag knowledge and the representative lists and the more substantive obligations that go to the knowledge of the ISP and then what obligations they have upon acquiring that sort of knowledge.
So that, I think, picks up on a question that I had during the last panel, which is how do content owners typically go about notifying conduit service providers of infringement on their platforms? Because that was obviously it sounds like, Mr. Midgley, you still are receiving notices that purport to be 512C notices in some cases. There was an issue, previously in the Cox case about service providers rejecting those sorts of notices. I wonder if you have any sort of insight that you could provide as to the practice in your industry of how rights holders typically go about providing this information.
I mean, it's somewhat variable depending on the nature of the service, but we do send DMCA compliant notices both to 512A providers and 512C providers.
I wanted to, Ms. Moss, Ms. Rothenberger, did you have comments on repeat infringer, or you did? Okay, because I think, okay.
Real quick, as I listen to the issues raised here, can you hear me?
Oh,
No,
you
just
turned
my
it.
mic's off.
Thank you. As I listen to the issues raised here and in the earlier session, it occurs to me that a role that the Copyright Office might have if 512 isn't completely revamped, as I earlier suggested it might be, it would be to provide best practices, to convene the different industries, the different types of service providers, and have best practices for both adequate repeat infringer policies, and also for going into probably the next question, for red flags knowledge, where it really differs by industry. And in that way, the service providers couldn't say, oh, a watermark doesn't necessarily mean infringement. I mean, they would be educated in terms by industry.
Sure.
Just to quickly branch off that note, something that our street's been looking into with Legislative Branch Capacity Working Group is this idea of capacity within legislative branch, so the first branch, which Copyright Office is part of the Library of Congress, so y'all include that. And something the PTO has instituted is the PTO Inventor Assistance Center, almost like a toll-free call number where I can call PTO and ask a question. We have that for basic services like the internet. I can call my internet provider and say I have a question, how to fix something, and because I am paying service provider, they have to offer me an answer. I think there could be an interesting avenue, maybe through the registration process and fees allotted to offer this kind of assistance to rights holders.
So we have a public information office, and they answer hundreds of thousands of questions every year. So that might be something where they could call.
It could be looked into in the Copyright Office, and I just think that'd be an easy way, not to solve the problem by any means, but to offer avenues for legislative branch to continually beef up its capacity. If the PTO can have it within the administrative branch, there's no reason in my mind why the legislative branch can't do the same.
Thank you. I'm going to go to Mr. Cooper-Schmidt, and then I think we're going to have to move to the next topic.
Yeah, I'll try to be brief, and sorry for getting in the way of you moving on. But there's a lot of discussion so far on this panel, and also on the first panel, about this one-size-fits-all does not work, and I don't disagree with that. But if we're going to consider that for ISPs, we really need to consider that for the other side of the equation, which is the creative community, right? One size fits all for the DMCA doesn't work for the notice system either. For the little guys, the small businesses, the individual creators, it just doesn't work. They can't afford to bring these expensive suits against these ISPs, these repeat infringer suits. They can't afford to be sending these millions of takedown notices that the music industry might be sending, or anyone else for that matter. They are truly sort of, if you watch Star Trek, they're the guys with the red shirts, right? They get beamed down to the planet and they're toast. Immediately the guys that die, they're the expendable group here, if you will. So I think that needs to be taken into account. If we're going to take into account how the DMCA works or doesn't work for the small platforms, we also need to take into account how it works, or frankly doesn't work, for the smaller creators.
Thank you. So I'd like to turn to the issue of storage at the direction of the user and how that relates to the no duty to monitor provision. And Mr. Brand, I know you mentioned the Mavericks case. So obviously we've had two recent Ninth Circuit cases, Mavericks on the one hand and Motherless on the other, both of which involved service providers that provided some level of human monitoring. And so I wonder what your views are on the extent to which these cases have clarified the law with respect to 512C eligibility, particularly on the issue of when something should be considered storage at the direction of the user.
Well, I don't think they've clarified the law. I think they've muddled it. Like I said, I think Mavericks sort of went in a bad direction. Motherless sort of improved it a little bit, but I guess it just really seems to be treading in very dangerous area, especially as was indicated on the previous panel. I mean, this issue of moderation, what is appropriate moderation? It really, it's a very fundamental issue that goes way beyond copyright, and it gets into, and it gets into 230, but then it also gets into, these broader issues of, what do we want the internet to look like? And it seems.
It also goes to copyright, though, right? Because it says 512C says ability to control such activity, and some of the case law goes. And we have to reconcile copyright,
right? But
and think about it in context of these other issues, which are very important that we've heard about at the other panel,
right,
too.
but 512M says you can't condition eligibility on monitoring, and so it really sort of the sense of Congress both in 1996 when the CDA was being discussed, and then in 1998 when the DMCA was being discussed, was that there wasn't going to be requirements to monitor, but that people were going to be encouraged to do it, because there was this recognition that monitoring was a good thing and moderating was a good thing. I mean, moderating, not monitoring, but that you wanted to have, if possible, human involvement, because you couldn't make all these determinations algorithmically and so forth. And so that's what's so troubling. Now, it could be that in the specific facts of Mavericks, you could sort of say, well, okay, there was so much human involvement, and that they sort of numerically were filtering out 2/3, 3/4 of the content. So it really was sort of a situation like a publisher that where 100 submissions, 100 authors submit novels and only one gets published.
Well, that's
right?
what.
But it's.
I'm sorry to interrupt, but I mean that seems to be the point that I think we were trying to get at when. I mean, at the beginning you said that Mavericks. I don't know if you said it was wrongly decided, but you said that it has sort of muddled things, and it seems to me that there was quite a lot of content-based selection going on in that case. If that doesn't constitute storage at the direction of the service provider, I don't know. It's hard to think of examples that would. Isn't it?
And I guess, and I don't remember. My recollection was that in Mavericks that there wasn't anything that I'm sure there was in the trial court, but I don't remember in the appellate decision if there was any sense of quantification. But and obviously you don't want to have hard and fast rules, but I think quantification does give you a sense of how much.
Quantification in terms of how much.
Well, right.
What
Again,
actually,
at what point do they stop? Does it really? If I'm the service provider and I'm a platform and I'm getting in hundreds or thousands of submissions a day, and I'm just kind of doing this very quick and dirty, cat video, yes, something else, no, that kind of, and again, it's not even me. It might even be again the community that's sort of or volunteers who are doing that. That's one thing. And then if you end up with, let's say, 80% or 90% of the content that is submitted by users, that ends up going up, then I think it's pretty easily to say, yeah, that is storage at the direction of the user. On the other hand, if you have a situation where, 90% gets screened out for a variety of reasons, including that it's not appropriate or the quality isn't good enough. I mean, you really do have these sort of editorial decisions. Then it starts looking a lot more like a publisher, and then you could say, well, that starts looking, and again, it is a continuum. And in the specific facts of Mavericks, I don't know. I don't know if were they screening out 10% or were they screening out 90% or it was somewhere in the middle. But all I'm saying is that some of the language and in that decision was troubling and reflected a lack of sensitivity that, again, Motherwell to some extent corrected. But still, the bigger point is that we don't want to we don't want to put platforms in this impossible decision, in an impossible place where if they try to moderate or try to look at make sure that the stuff is really appropriate, that they end up losing their safe harbors.
Thank you. Ms. Castillo?
Thank you. I think it would be helpful for the Copyright Office to look at these two cases to stand for the proposition that screening material for potentially infringing content is an activity that enhances public accessibility of content stored at the direction of the user and does not expel an ISP from the 512C safe harbor. The types of screening in these two cases were very different. Motherless was screening for illegal content. Their policy was, again, anything legal stays. And so the court there found that this was an activity that was acceptable for purposes of the safe harbor because it would still render the content to be stored at the direction of the user. The type of screening in LiveJournal was different. It was for substance. The court called it manual, extensive, and substantive. And it was a much closer call. And one thing they were not screening for was infringement. And so at that point, I think what's helpful from these two decisions is that if an ISP is screening for substance and it's not screening for infringement, then it is possible that it will lose its safe harbor. In Motherless, the ISP was simply screening for illegal content, including copyright infringement. I think these decisions are helpful in that they attenuate to some extent the ISP's incentive not to look at user submissions for infringement, and they also clarify that screening content for substance is not an accessibility enhancing activity, and that the ISP might lose its safe harbor if it engages in this behavior. I think one other point I would like to make is that we disagree with court's interpretation of Section 512M so far. The title of that provision is Protection of Privacy, and both the Senate and the House report make it clear that Congress's intent with this provision was to prevent ISPs from violating privacy laws such as the Electronic Communication Privacy Act when they were pursuing efforts to address infringement. This section was not meant to say that ISPs have no obligation to monitor whatsoever when it comes to copyright infringement.
Thank you.
Yeah, I want to ask a quick follow-up question on that. If I understood correctly, you were saying that to the extent that a service provider is screening for illegal content, they should also be screening for copyright infringement, which is illegal. Mm-hmm. So the question there I have is, does that mean that if a service provider is screening for child pornography and snuff films only, that they are going to suddenly be out of the safe harbor? And if that's not what you're saying, what is sort of the limiting principle between screening for no illegal content and all illegal content?
No, that's not what I'm saying. What I'm saying is what the court said in Motherless was that screening for illegal content of any kind, so child pornography and copyright infringement, were things that Congress could not have meant to discourage by eliminating the safe harbor. So what I'm saying is that if ISPs are screening for illegal content, including copyright infringement, then they shouldn't lose their 512C safe harbor. Does that make sense?
It does. My question is, what if they're only screening for some illegal content, but not copyright infringement?
That's a closer question, right? Because according to the LiveJournal decision, where there isn't any discussion of screening for any kind of illegal content, in that case, the court seemed to think that on remand, the ISP might lose its safe harbor.
Mr. Carlisle?
I think that content moderation is a good thing, and that it should definitely be encouraged, because the alternative to that is no moderation at all, and it just becomes an absolute, free-for-all and cesspool. I think that perhaps by getting better practices out there, that we could solve a lot of these particular problems, and I'll reference some from my own experience. I used to be a musician and write songs. Now, in order to get these heard, I placed them on a website called Reverb Nation. Now, according to Reverb Nation terms of service, I had to warrant that I was the author of the material, or I had properly licensed material, or it would not go up at all. And I think that a lot of the problems that we're experiencing with red flag knowledge, and a lot of the experience about, well, it's got a watermark on it, but who owns it? We could have better practices along these lines. Before we get posted at the direction of the user, perhaps the threshold question is, who owns the material? Is the user who's posting material claiming to be the owner of the material? Are they the proper licensee of the material, or is the material in the public domain? I think that these factors would go a long way to eliminate a lot of the guesswork and the problems that we're experiencing between the Mavericks case and the Motherless case about how much content moderation is required.
Doesn't Google already, Mr. Donaldson, maybe you can answer this, but doesn't Google require people to affirm that they have the rights to upload whatever it is they're uploading?
Yeah, our terms of service include that you have the right to upload what you're uploading.
So, Mr. Carlisle, I wonder, are you suggesting something kind of from the regulatory standpoint that
Yes.
would, okay.
Yes.
Yeah, actually, if I can follow up with Mr. Donaldson. So, following up with Mr. Carlisle saying, could you maybe explain a little bit if the situation happens, when folks are using Content ID, and I understand there are a variety of additional products that are offered on the YouTube platform, to answer the question about of your connecting the copyright owner and the alleged infringer to take their dispute offline to go to the contract question that Mr. Carlisle raised. Is there anything you can share about maybe some of the experience you guys have seen in the use of both, not only just Content ID, but also some of the other tiers of service that your
Sure,
platform's
absolutely.
offering?
Content ID resolves 98% of the copyright disputes that arise on YouTube, so it's been very effective. We've also just recently introduced the copyright match tool, which you've alluded to, and that allows smaller creators to easily find matches to their works and file takedown notices in a much more streamlined way. We've rolled that out now to 400,000 smaller creators, and we're continuing to expand the universe of people who are eligible for a copyright match tool. So, we've seen good results. To circle back to the Beyonce question from earlier, those songs are a demonstration that the record label wants those songs on the platform. Beyonce's record labels, they're licensed, and in most of the cases, if you can recognize the song, so can Content ID. And if Beyonce or some other artist chooses to monetize some fans' upload of the printed lyrics and the song, we're happy to help with that.
Can I ask you, is that always going to be clear that the Beyonce or whoever the rights owner has opted to leave that up, or how do we know that that's true? I mean, you two may know, but
Yeah, it's complex. I don't think there's an easy way for the public to find out. It's true, though, that YouTube has more than 1,000 deals with music rights holders, including all of the largest music rights holders. So the vast majority of content on the service, its music is licensed. I'll say further that in general in the music industry, there's a huge problem with incomplete data. That publishing houses and record labels to some degree and collecting societies can't or won't reliably tell you exactly what the list of works is that they represent. And so we're working with incomplete information.
Mr. Levy, did you want to engage with that? Because I think sometimes independent musicians have a slightly different perspective.
I absolutely did, yeah. Sorry. I absolutely did. Content ID and Content Match rely on representative lists. And it's fine for publishers that have direct arrangements with YouTube. But a lot of our independent publishers and certainly songwriters don't have those direct deals, and therefore as far as I know, are unable to submit a representative list that would keep their content off of YouTube. Is that right?
Content ID doesn't rely on a representative list. It relies on ingesting a copy of the music to make a fingerprint is even too simplistic to make a statistical representation of that song.
It's submitted by the labels, which is essentially the same thing, right? Here's a list of content that we want to protect.
It's not a representative list. It's a complete list of the things that we'll protect.
Well, what about the broader point? You know, in the last roundtables, we did hear from individual music creators in particular who were concerned that Content ID wasn't available to them. Has that changed in the intervening years? And is that, have there been efforts made to sort of expand the universe of rights holders who are eligible?
There has been some growth in third-party aggregators of claimants, so the people who will work with a smaller rights holder to send Content ID notices. There's the copyright match tool, which I just mentioned, that we're very proud of. That's a tool better tailored to smaller creators. And
why is it that Content ID doesn't work well for smaller creators?
Content ID is inordinately powerful. It's very complicated to operate and administer. It allows sophisticated larger partners to specify amounts of their material that they're willing to use, for example, thresholds. And we've seen examples where even from those Content ID partners, a user who isn't as experienced at Content ID can take down or wrongly monetize a broad swath of content.
Is there an obligation, this might already be in the record, but is there an obligation to monetize a certain amount of material through Content ID, or could you just use it all for a takedown?
If you were a Content ID partner, you could take it all down.
Mr. Dorshow?
Yeah, just returning to the discussion about moderation and when if a service provider chooses to screen certain illegal content but not copyright infringement, should they lose the safe harbor? I think it's our position is if the means to screen for copyrighted material exist, and they do, then there is that obligation that if a service provider is interacting with the content on its site for the purpose of improving its bottom line and making it a more appealing site and benefiting from the presence of the copyrighted material, and it has the means available to screen that copyrighted material out, then we would say yes, you would lose the safe harbor for that reason. And there was enough discussion, I suppose, in the first panel, so I won't belabor it, that the availability of these tools, now Content ID, obviously Google invested a lot of money and built its own solution. There are other solutions out there that are not so expensive and costly, and if those are reasonably available, then we think that is an appropriate condition of the safe harbor.
Well, so I want to follow up on that question, but first I do want to go back to Mr. Donaldson just to clarify a point. At the outset, you said that Content ID was a $100 million system. The last time we did these roundtables, now it has been 3 years, it was a $60 million system that everybody was saying should be given to every single ISP in the world. Is that because of subsequent investments? Does that include other things like content match and stuff?
I think we said more than 60 million, but I'd have to check the record. And as far as I know, the number is accurate. It's $100 million.
So I just want to follow up though on this. Last time around, we heard that everybody needs to be using filtering technologies. Maybe they can't afford something as sophisticated as Content ID. They certainly would take years to develop even if they could. But since then, and even at the time, numerous large service providers had some sort of filtering technologies they were using. I'm sure more have been developed in the 3 years since, or 2 years since the last round of comments. So I'm curious to hear a little more on what has been added to the ecosystem and whether or not, what the feelings are as whether or not we've reached a point where filtering technologies, whether it's Content ID or something a little more rudimentary, are STMs.
Just to quickly follow up on your first question, it's inaccurate to refer to think of Content ID as a static entity, and it's the subject of major ongoing investment all the time at Google. So, an additional $40 million of investment, give or take, in the last 3 years sounds reasonable to me. It's the work of many people at the company. As to whether they've become standard technical measures, I mean, under the statute, I'd say no, because they're not in widespread use. And so that, that's something we would, we'd have to consider.
Mr. Hudson?
So I think some of this fails to account for the long tail. That, when you're doing long tail content, non-digital content, small creators, this filtering technology for the foreseeable future isn't going to be comprehensive. Just like with the repeat infringer policy, you're now faced with the question of how much of a filtering technology is sufficient for you to stay inside the protection of 512. It's not going to be comprehensive. If it's not comprehensive enough, do you now lose protection? We're just we're moving the question over, but the uncertainty still remains. I think that's why the flexibility of the current regime and the ability to tailor it based on the size of the entity, the type of content content creators needs to be taken into account. And simply just changing it to add a filtering requirement isn't going to solve the problem.
What's your response to the argument that, at a minimum, you could filter entire works, for example, and that the universe of instances where the uploading of a full work is going to be licensed or fair use or otherwise permitted is relatively small? I mean, why couldn't filtering technology at a minimum capture full works?
What if the full work is a quilt? How do you? Our minds are set for digital content, and a lot of the content that's being shared or discussed isn't digital. It may be a picture of a digital. The picture of it may be digital, but it is. It gets inordinately complex when you're going one or two levels beyond that. If you're talking about a full copy of a movie or an audio work, I think that's where there's been technological work done here to help solve that problem. But my point is that there's a huge long tail, and that long tail, when you add it up, is significant, that the technology that everyone's been talking about just doesn't work for.
I don't want to lose the forest for the trees here, but just so we're talking about the kind of content that might be uploaded to Etsy, let's say a full image of a movie poster printed on a T-shirt, right? Like, why isn't that the kind of thing that could be screened out?
I think it depends on the type of technology available, and how reverse image search, how other technologies could be applied. I can't speak to any one particular instance, and there are also issues where there are things that are old and things that are new. We can't determine, for example, there could be a vintage T-shirt that has something on it, or a vintage poster. So we're not generally in the position to know whether that vintage is correct or not unless we get assistance from the copyright holder.
Has Etsy changed its policies at all following the Zazzle decision, or do you view that as just qualitatively entirely different, because in that case they're printing it or producing it themselves?
We do view that as qualitatively different. Etsy is kind of a pure marketplace, a pure platform. We don't handle goods. We don't do drop shipping. We don't print on demand. Users are responsible for their own content. So we view it as a different set of facts and a different issue. That said, we do have a repeat infringer policy. We do have kind of a comprehensive set of policies to deal with intellectual property issues and corner case intellectual property issues such as counterfeiting, which we view as slightly different.
Mr. Cooperschmidt?
Oh, thank you. So on the issue of filtering, I'm going to take a line with Sasha said earlier, which is about the DMCA, that perfect doesn't need to be the enemy of the good. Here, and we tend to talk, when we talk about filtering and screening and monitoring, we seem to just focus on the extremes. And there's a huge middle ground there, right? And this isn't just a black and white issue, that there can be monitoring and screening and filtering, or whatever you want to call it, that can be done in a way that takes into account different concerns and different types of examples. And just to identify a few, I think, Brad, you had mentioned sort of the full movie example. What about a test that is never licensed to anyone, is held sort of in secrecy, never found online? I mean, if you notify a platform that that test shouldn't be up, that should be good, so it never sees the light of day. I mean, that's just, one example. The example that Mickey was talking about earlier today about metadata on a photo, and then the response question was, well, what if that photo is licensed? Well, just because you find metadata on the photo doesn't mean that that photo is automatically just taken down. Why isn't there a middle ground here, right? Why isn't the question asked to the person who's posting or trying to post that photo is, do you consider this fair use? Are you the copyright? Are you a copyright owner? Are you licensed because your name differs from the name that's on the metadata? There's a middle ground. I mean, hell, man, I every time I go to a website, I'm asked if I'm a robot. You'd think that you could come back and just ask a question, ask a question in that regard. I think, in short, and what this roundtable and all the roundtables are not about solving the problem. It's about getting us closer to solving the problem, getting us to a place where we are right now, where things are really, really not working. We need to close that gap. We really do. Because, I mean, there's a desperation out there. I spoke on behalf of little guys, but it's not exclusive to little guys. It's across the board. And, when it comes to filtering and screening, monitoring, there's absolutely more can be done.
I'm going to jump back, if it's okay, to Mr. Band, just to see if you had a response to that last point about filtering.
Right. Well, and I think this gets this gets to the whole moderation point, and certainly, in the example that we heard from Etsy, I mean, if you have an image from a movie on a T-shirt, I mean, that very well might be fair use. It all depends on what if there's on the context and the purpose of the image, and that could obviously, if you have an automatic filter, that could be a problem. But with respect to, getting back to Sophia's point about moderation, so imagine you have institutional repositories. So that's a lot of the kinds of platforms that libraries and universities have, where they have a platform where people can for a department or whatever. Now, it could be that in some cases, especially if you start having a very large repository, that you want to have some degree of moderation to make sure that the stuff that's being uploaded really belongs there. Well, why should you? It doesn't make sense that you would lose your 512 safe harbor by virtue of that, by virtue of making sure that the stuff that is uploaded there is appropriate to that website, as opposed to just looking to make sure that it's not illegal content. And I'm even thinking of a repository like SSRN, which is owned by one of your members, Reed Elsevier. They have huge amounts of content, and a lot of us in the room have probably uploaded content to that site. It doesn't go up automatically. At first, it has to be reviewed by someone at SSRN who is, and I don't know what they're screening for, but among other things, they're deciding where it's appropriate to go.
But doesn't
it's
that,
also,
I'm sorry to interrupt, but I mean, that sounds like volitional conduct to me. I mean, that sounds like, someone making a choice, the intermediary, the service provider, making a choice about whether or not to post something. I mean, if I were just to email you, some materials, and you had your own website, and you decide, even if you post 100% of them, it seems to me that there's an argument that while I have expressed my view that I think they should be uploaded, ultimately you're the one who kind of says yes or no.
Right, but I still think, at least for purposes of 512C, it is that uploading is at the direction of the user.
But if
And-
you have
and
the
it should be-
ultimate choice, then how is it at the direction of the user? I mean, I take your point about, a sort of high-level filtering for illegal content or something of that nature, but I just wonder how we sort of draw the line properly if we at some point are talking about whether the content is suitable for the platform.
Again, it just seems to me that if it's under the terms of the statute, it is the user that is sending the stuff, and if basically everything was going to end up on the site, so long as it is, the kind of thing that should be on that site, that's a very different situation from the traditional publishing model, where you really could say, okay, because they are making that kind of qualitative decision that only, one submission out of 100 or out of 1,000 is going to be disseminated. I think that just falls on a different place on the spectrum.
I'm sorry, Ms. Rastenberger, you've been patient. Thank you.
Thank you. A couple points. I want to go back to what Mr. Carlisle said about, having some sort of, I affirm that I own this, I licensed it, or it's fair use, and terms of service are not enough for that. I mean, we all know nobody reads the terms of service. So to echo what Keith said, I think it would be really good if whenever you uploaded something to any site, you have to say, I own it, or I licensed it, or I believe it's fair use. Why not? I mean, not only do you have to now say I'm not a robot, but you have to identify bikes or storefronts or something. And if you don't have very good eyesight, that's sometimes hard to do in those photos. So I also, though, one thing we haven't talked about, and I want to make sure we do, is the question of who the user is. And I know the Mavericks case touches on it, but we also haven't talked about the bad actors here, and how ineffective 512 is against the really bad actors. So I want to give an example of a site right now that we've been dealing with for a couple years already. It's ebook Bike. It's owned by a gentleman named Travis McRae, who founded the Pirate Party in Canada. He also is one of the principal members of a religion called Copymism, and hosts their website. The sacrament for Copymism is that copying is a sacred duty. So he owns this site. He hides behind Section 512, and I will say for most of the ebook piracy sites that is true. They say, oh, we don't know anything about it. It's all user uploaded content. Now, to upload content, you have to become a member. Most of the members we know are part of the piracy party or related. If you're a member, you are instructed on how to buy an ebook, strip out the DRM, upload it to the site, and then return it, so you don't even have to pay for the ebook. So I just want to make sure that we think about these kind of cases. We have sent notices to, authors have, independently, and we organize groups of authors to do this, send notices to ebook Bike. Sometimes it works, sometimes it doesn't. I mean, sometimes the site doesn't even work, the notice form. We have sent notices to Google. We have sent notices to the servers. Now, the server provider did take it down, but of course he just went and got another server, right? And this has been over 2 years we've been struggling with this, completely ineffectually. When we started, it was mostly the independent authors' books that were there. Now, all fiction works are there. Particularly, any popular fiction books can be found on ebook Bike now, and we are left without anything that we're able to do other than to bring a lawsuit and litigate whether 512, whether they're protected by 512. But with all of these open issues, we can't do that. Those cases cost millions and millions of dollars. which authors can't afford to do. And who knows what the outcome would be.
I just want to follow up on that a little bit. You know, in the first roundtables, we also heard a lot about these sort of pirate and bad actor sites. But do we really think Congress ever intended to cover those types of sites in 512?
Of course not. But the way that the courts, particularly the Viacom YouTube case and the VO case, which have now become the ingrained law in all of the circuits, make it possible for the bad actors to be protected. Or, I mean, it's possible that we could win a litigation, but you have to go through, because the burden has been put on the copyright owners in pretty much every aspect of 512, except for the repeat infringer policy. Those cases are very, very hard to prove.
But what is the answer? Is the answer to pull back 512 for everyone, including the good actors? Is it to have a clearer off-ramp for the bad actors? I mean, how do we deal with this without blowing the system up?
Well, that's a really good question. So, as I said before, I think that we should have best practices that are in the law, or at least regulations for what red flags knowledge is. And I think Congress should step in and say and clarify that knowledge and red flags knowledge do not mean only knowledge of a specific infringing item at a specific location. That is the problem. Knowledge that your site is a place for piracy, that pretty much everything on the site is pirated, should take you out of 512. And that you should be able to win, on summary judgment.
Thank you. So we're running low on time, so I'm going to ask Ms. Moss if you have a comment on this topic, and then because we're short on time, I'm going to sort of introduce the next topic. One or two of you during the introductions mentioned 512F, and so I invite folks to state their views about the state of the law with respect to 512F, particularly post Lens and post the denial of cert in Lens. Feel free to answer. Yes, of course.
So three really...
Oh, I think your mic is. Oh, it is. Okay.
Three brief notes. The first is regarding my friends, Ms. Brethenberger and Mr. Cooper-Schmidt's point regarding this kind of idea of verification when you upload. That's putting onus on the user. And I don't know about you, most users don't have a legal education, and they don't know what fair use is. And they might not read the terms of service to find out what fair use may or may not be. The second brief point is regarding filtering technology and upload filters. Upload filters are not working as properly as I think many around the table like to say they would be. For example, in the EU, a parliamentarian had her video taken down off of YouTube because it said there was infringing content in her video. It was a speech on the floor of the EU Parliament. And the third note I just briefly want to mention is the moderator's dilemma, this idea of seeking after content that may or may not be infringing. As we saw with the passage of FOSTA and SESTA and CDA 230, this creates the moderator's dilemma of what can or cannot I take down, or am I taking down legal content versus the infringing content as I intended to do so. And that'll wrap me up so you can start doing 512F.
Okay, thank you. Mr. Levy?
Yeah, now we're on 512F?
Yes.
Excellent. So Lens is still a major problem for us because it appears to require, it does require that a copyright owner consider fair use before a takedown notice is sent. It doesn't give any real guidance as to what that means, what considering fair use is. It's kind of hanging out there as a potential time bomb for us. Again, for small publishers, and certainly for songwriters who may have just massive amounts of infringing examples of their works out on the internet, to have to engage in a 4-point analysis of fair use prior to sending a notice for each and every one of those would be truly burdensome and potentially expensive if you have to have someone on staff to deal
Well,
with it.
do you interpret that case as imposing a one-size-fits-all standard on everyone, or can you look at whether it is an individual copyright owner or an individual user filing a counter notice who may be less sophisticated than the defendant in that case?
I don't think the ruling really helps us make that determination.
It seemed like you mentioned that Lens is a problem, but didn't actually. I didn't hear you actually talk about automation and in fact whether or not you can use automation in making a fair use assessment. The last time we did these roundtables, we heard there was some sense that there probably was still some room there. My question is your thoughts on what, with Lens Cert denied, whether and how the Ninth Circuit has left in place room for automation.
Well, again, I'm not sure if it's addressed it directly. It seems as if language regarding automation has been taken out of the second version of the opinion. That's a concern for us. It might very well mean that they're going to interpret it so that we cannot use automation, which again increases our cost burden and ability to protect our works.
So we're running out of time, so I think we're just going to do kind of a lightning round. I urge you all to be brief. Mr. Hudson, do you have a response to Mr. Levy's concerns?
Only that you just need to keep in mind that the platforms are in the middle there. We're not in a position to make fair use determinations. You have to rely on the data provided by the copyright owner, the responses provided by users, and in the world of filters, where does liability lie for the intermediary trying to just enforce the system as it is? So this is why an enforceable mechanism for 512F when either side violates their duty to follow the laws is important for platforms to enable copyright owners to get protection and enable users to express their own creative content.
Mr. Carlisle?
I think that for small creators, independent musicians, Lens becomes a good news, bad news joke. Fair use is incredibly complex. We can't even get the courts of this nation to agree on a simple standard for fair use. Everything has to be examined on its merits. And for an independent musician to be required to make that kind of assessment before sending a takedown notice is really burdensome, especially when the alternative, when you take red flag knowledge, we have these very sophisticated companies professing that they have no idea what a red flag knowledge is or whether it's something infringement. From my standpoint as a musician and a creator, it's much easier to figure out whether something's infringing than whether something is in fact fair use.
But I mean, isn't the statute sort of premised on the idea that really, you know, it's going to be the copyright owners who ordinarily are going to, you know, have the most knowledge about whether the use is authorized and in general should have the responsibility for monitoring platforms? I mean, isn't that sort of the basic bargain that was struck?
Yes, and I think it was the wrong bargain to strike. I think putting the sole onus on policing the entire vast internet on copyright owners, some of whom are very, very small and don't have the money or the time or the ability to monitor the entire internet 24/7, I think it was the wrong balance to strike.
But to drill in on the misrepresentation part of the statute, 512F, I mean, this is only liability for knowingly, materially misrepresenting that something is infringing or doing, you know, the same type of representation for a counter notice. So if you are someone and you have a honest mistake as to whether something is fair use or not, why is that a problem? If it's complicated and you do your best and you're not knowingly, material misrepresenting, is 512F really a risk?
I think that the problem, again, is it goes back to material misrepresentation and what the ultimate standard on that's going to be. It seems to me that even the court in Lens struggled mightily with what Mrs. Lens was doing was, or rather what Universal Music Group did, was a material misrepresentation. There you have a very sophisticated, you know, actor. I think that, I think it's a very gray area, and I think it's a problem.
Yeah, I think I'm suggesting for the little guy, the word knowingly is very helpful on both sides of you know, the system.
Yes, but again, you're dealing with somebody who may be a creative person. They may know something about copyright, but again, that knowingly part of it, musicians can get incredibly aggressive when it comes to asserting their rights. And sometimes they're right and sometimes they're wrong. And especially in an area with music where there is a lot of homogeneity, and there's a lot of musicians out there who will hear any similarity as being infringing.
Okay, Ms. Castillo.
Just a quick response to Mrs. Moss' concern with the taking down of legal content by over-aggressive filtering. I think that's what you were referring to. I think for those cases we have the counter notice system, and that is working. So I think concerns with the accidental takedown of legal content should not be a reason not to implement filtering or not to look at filtering as a solution for rampant infringement online.
Okay. We're going to go to Mr. Band, and then I think we're going to have to close things down. But we do have our open mic at the end, so if there are things left unsaid, feel free to sign up for that.
So this is in response to Mary's point about litigation being expensive. Yes, it is litigation, and many lawyers in the room like the fact that litigation is expensive. But putting that aside, the point is courts are very good at figuring out who's a good guy and who's a bad guy. And if you're a bad guy, courts find a way to hold you liable. Napster lost, Grokster lost. I think sometimes sometimes rights holders, either they're not as careful as they should be in selecting their defendants, or they have a misperception of who's a good guy and who's a bad guy. It didn't really make sense to go after YouTube. It really didn't make sense to go after Google. Doesn't make sense to go after HathiTrust. Courts, when they look at these defendants, they look at the balance of what's going on, and they will usually. They're very good at figuring out who's abusing the system, and they will find a way to shut them down.
We had, I think, a reference to the HathiTrust case, so I think we're going to let Ms. Rosenberger respond.
Thank you, I appreciate it. I won't talk about HathiTrust, which I was not at the Authors Guild when that was brought. But I do want to just mention good actors, because I mentioned bad actors before. Good actors who want to keep pirated ebooks and audiobooks off their site can do it, and they do it. Amazon uses fingerprinting, and they are pretty successful at keeping pirated copies off their site, and when something slips through, they work with us, they take it down.
I think we're going to have to leave it there. Thank you all very much. We will start back up at 1 o'clock.